One of the students asked me to explain the case law Box versus Jebb 1879 with regard to vis major or act of God. Please remember, I have explained you this case law in exceptions to strict liability, that is act of third party. So strict liability, you all know, Justice Blackburn has propounded this theory of strict liability in the very famous case of Rylands versus Fletcher 1868, he has, in this case, he has come. So, even though you cannot expect any negligence on the part of the defendant, but still the defendant is liable to pay compensation because there was damage to the party. But you can escape from paying the damages if you are able to put the case in any one of the defenses, like number 1, plaintiff's own default; second, act of God; third, act of the third party; fourth, consent of the plaintiff; and fifth is statutory authority. Now actually this case comes under the so-called act of third party, or sometimes you can call it as a vis major, because the judge himself was not able to decide whether it is act of God or the act of third party. So this is a very famous case called as Box versus Jebb 1879. So in this connection, first of all, you have to know, I am giving a picture to you, please know it. So here what happened is, the claimant, this man, he filed a case against the defendant as though the water came from his reservoir and spoiled his land. This is the case filed by the complainant against the defendant. But the defendant now says there is another reservoir by a third party, another reservoir belonging to a third party. This man has breached it. The water came to this defendant land and overflown into the land of the complainant or plaintiff. So therefore, there is no fault on his part, because it is the intervention of the third party who has allowed his water to overflow into the defendant's reservoir. Please remember, in Rylands versus Fletcher case, what happened? Actually, Fletcher did not know the existence of the coal mine by his side. He actually simply asked his independent contractor to build a reservoir. It was built, but it was filled with water, and after that only, by the next day when they came, they saw the water entered to the field of Rylands through the disused shaft. But here there is a third party, the defendant. What he says, even though Mr. Box, he filed a case against Jebb. So Jebb says that there is a third party, another party. He has constructed reservoir. That fellow has allowed the water to come into his reservoir, with which it was overflown and damaged the fields of the so-called plaintiff. So here, since it is the act of the third party, right now I will read the case. The defendant had a reservoir on their land. There was another reservoir situated at a higher level, please remember, than the defendant's. The owner of the so-called other reservoir emptied it, totally vacant, emptied it through a drain connected to the defendant reservoir. So through drain, he has allowed the water to come into the defendant reservoir. The defendant reservoir was overflown and damaged the complainant's land. Right? So actually, the complainant brought action under basing on that Rylands versus Fletcher case. And he said that the water is for non-natural use of the land and other things. And there was escape of land, just like that Rylands versus Fletcher case. But the court held that the defendant was not liable for the damage, as it was caused by the act of a third party over which the defendant had no control. So Chief Justice Baron Kelly, he stated, the matters complained of took place through no default or breach of duty of the defendants, but were caused by a stranger over whom and at a spot where they had no control. It seems to me immaterial whether this is called vis major or the unlawful act of a stranger. It is sufficient to say that the defendant had no means of preventing the occurrence. So you can cite it as an example, better you cite it for the so-called act of third party. But here, the judge, chief judge himself said, you take it as a vis major, you take it as third party, but the defendant is not liable. So therefore, that is the advantage of the so-called cases. So please read the case thoroughly and enrich your legal knowledge. Thank you very much.